Hello, I'm Professor Theo Myrie with the University of Washington School of Law, and we are on our Week 10 lecture regarding race in the law, focusing primarily on the Black Lives Matter movement and qualified immunity. So let's begin this discussion actually by setting a little context. So the Black Lives Matter movement it happens in a very particular social, political, and cultural context. All right. Now, by that I mean there has been a very long and extensive racial history in the United States. And in that racial history, there has been a tension regarding how the government or law enforcement in particular interacts with the populace in the United States, particularly racial minorities. And given the history of the United States, particularly again, African American or black members of the populace. Okay. So when we're looking at that context and we're looking at the history over time, some of the tensions that are happening there are around police violence towards individuals. All right. The Black Lives Matter movement is not a movement that says no one else's life matters. Okay. What it's actually saying is that the structural racism that is present and the race violence that is actively engaged in has reached an intolerable level. So to direct attention to this point, right, the tipping point, then BLM enters the stage. Now, there is in the way the rules regarding the interaction between police and the populace are controlled, there is in that all the various constitutional protections, right? The particularly the criminal protections in the Fourth and Fifth Amendments. There are also the Reconstruction Amendments later on, such as the 14th Amendment or the 15th Amendment, things like that. There's also at the judicial level for cases that have interpreted and applied these sorts of laws. There are a lot of judicial tests or ways of navigating it. The typical way of navigating certain situations is as a balancing test, weighing and balancing competing interests between people. So often what we have seen in a justification, a legal justification for police violence against racial minorities, especially black people, is police safety or officer safety, right, at that level. Now, there are a lot of other technical doctrines in the debates that people have around Black Lives Matter. And it doesn't matter for us, for today's purposes, whether you agree with BLM or disagree with BLM. BLM is pointing to an actual structural problem. Okay, that is real. So that part of the debate is not debatable. All right, the what to do about it, right? What led to it, where to go to from here, these are debatable. All right, and there are multiple viewpoints associated with this. What we need to do in our Introduction to Law class is understand what legal doctrines are implicated within the critique that BLM is making of our legal system, particularly of law enforcement. All right, so that's where we're beginning today. So let's turn to our PowerPoint and see where to from here. Whoops, sorry about that. Okay. There we are. Okay. So as I said, we're focused on the BLM movement and the idea of qualified immunity, or the legal doctrine of qualified immunity. Some of you may have heard of it. Some of you may actually know what it is. Others, this may be one of the first times that you are explicitly learning about it. So regardless of where you are on that spectrum, let's dive into some of the legal issues here. So what are the legal aspects triggered by the BLM movement, all right, for us to understand and to focus critically upon? The first one is over-enforcement, all right, and in the debates around police and racial minorities, or police violence and racial minorities, racial profiling is a term you're going to hear. So what does racial profiling mean? It's something that is resonant or adjacent to the idea of implicit bias, but sometimes it's explicit bias. This is where members of the police actually begin to look for unlawful activity or to begin an enforcement process of the law, where the presenting characteristic is not necessarily the overall facts and circumstances of a given moment in time, but is actually based on who the suspect is, all right, particularly the race of the suspect. Now, there's a lot of different things that play into this, and there's a lot of different studies that people can take a look at for implicit bias and what racial profiling looks like. What we need to be concerned with here is the fact that it does occur. All right, racial profiling is an actual thing. Now, what this does, right? When you have a legal system where the judiciary does not actually have its own branch to enforce the laws. Instead, the police fall under the executive branch, all right? And usually that's going to be under the mayor of a city. It could be as an elected official under a sheriff for a county. It could be something at the governor's level, such as the state patrol. It could be at the federal level. It could be with the Attorney General's office and the FBI, right? Things like this. So these are all aspects of an enforcement mechanism, but they're not controlled by the judiciary. All right, the judicial branch does not control them. The executive branches control them. All right, so where is the bridge between the judiciary and the executive branch? That actually comes from the interpretation of officer behavior in specific context. All right, now the second point I want to focus us on is the racialization of the Fourth Amendment. All right, and when I say racialized Fourth Amendment jurisprudence, that means when the courts are interpreting the constitutional protections in the Fourth Amendment and they're applying it to an individual case or controversy, right, before it, the decisions that they are reaching, right, involve cases where the suspect, right, or the defendant is black or African American, and what the police have done has been found to be legally acceptable. All right. Now, the court does not discuss the race of the defendant. Instead, the court is focused on what's happening under the facts and the circumstances. But if case after case after case has an unanalyzed racial component to it, and everything that the court is deciding is permitting the police to engage in the kinds of behavior that we are complaining of, which is extreme police violence, then what you have is a racialization, right, of that jurisprudence, right, of those cases. And it means that when we're thinking about things like warrantless searches, the stop and frisk, or something like that, the contexts that have provided us with the factual boundaries of what the police can do have mostly involved racial minorities, especially African American and black people. All right, so that's the second legal aspect that's triggered critically by the BLM movement. The third one is how grand juries function. All right, and in our criminal procedure lecture, we learned about grand juries, and now we want to dig a little deeper and look at the idea of how probable cause functions for a grand jury. The fourth thing that's triggered by BLM in terms of legal content is basically what's known as a 1983 claim, right? So this is 42 U.S.C. Section 1983. So it's the United States Code. It's a statute. It's a federal statute. And what it means is that when a person who is part of the government or acting on behalf of the government violates your constitutional rights, you have the ability to sue them under this statute. And what this actually means is that normally the government, when it's performing its duties, is immune from lawsuits. All right. So simply because you don't like what they're doing or what they're doing does not favor you, does not mean that you can sue the government. So sovereign immunity usually stops that. However, 1983 claims, right, create a statutory sort of exception and allow an individual to sue for deprivation of their constitutional rights when that deprivation was caused by the government or a person acting on behalf of the government. Now, there arose after this the fifth thing that we want to take a look at, and right now probably the most critical thing for us to take a look at, is the doctrine of qualified immunity. All right, this arose in cases where the judiciary was trying to figure out how to initially, to some degree, balance the interest between, say, officer safety or concerns about enforcement with the rights of the individual. All right, and in that balancing test, the court struck upon some language. All right, and we're going to dive into that. Now, that language has been expanded and deepened, and so there is a phrase in English called "the tail that wags the dog." All right, and what this means is that the exception now for qualified immunity has become so large, it's actually now the tail wagging the dog of 1983. So people are no longer able to use 1983 claims as effectively as they had been for a period of time. All right, so now let's go a little deeper into this. So when we're talking about kind of the first aspect of this, right, which is the over-enforcement and racial profiling, one of the things we're looking at is the Terry stops, all right, which we kind of mentioned in class from Terry v. Ohio. So these are the sorts of stops or warrantless searches, the stop and frisk scenario, that police can engage in depending on the facts and circumstances of the situation. So these stops and arrests often lead to escalation. They can lead to injury, and they can lead to fatal force by police. In terms of escalation, injury, and fatal force, these are some scenarios, right, which seem to be very, very common, but have in fact led to mostly the death or serious injury of people of color, particularly African American and Black people. So let's just take a look at this. Now, these are phrased in a slightly provocative way because it's to make a point, all right? And each one of these things actually is part of an entire scenario to think about, all right? So driving while Black, right, has led to escalation, injury, and fatal force by police. Smoking while Black has done the same, as has walking while Black, biking while Black, socializing in public while Black, riding public transportation while Black, arguing with another person while Black, using a cell phone while Black, playing with a toy while Black, being mentally ill while Black, shopping while Black, hanging out while Black, eating in public while Black, and selling things while Black. All right, these are scenarios that, generally speaking, should never lead to escalation, injury, or fatal force, all right, regarding any sort of stop or arrest. But they are all scenarios that have led to that very thing. BLM is actually focusing on this and saying this is just not the way it should be, all right? And it's hard to argue with that. If anybody corresponded to any of these situations and your life was at risk by simply doing it, right, then we would be very cautious with how we viewed the police, the government, and the judiciary. So let's explore a little deeper and see what some of the dynamics of this caution are. All right, so how does police violence occur within the law, all right, within the boundaries of the law? So let's take a look at that racialized Fourth Amendment I was discussing and see some of its effects. All right, now, one of the things I just want to remind you about, and I mentioned this, was the Terry stop. All right, the Terry stop occurs when a police officer has a reasonable suspicion that there is some sort of unlawful activity going on. Okay, when they have a reasonable suspicion, and all they have to do is articulate a reason, right? So this is not probable cause. this is merely a reasonable suspicion, then they can do a brief investigatory detention, so they can stop you and then begin asking questions. Now, we went through kind of an elaborate conversation about this in class as a constitutional dance between the police and the person who is being stopped by the police. All right, and with each question comes an answer. With each answer, it invites another question, and the dance continues. Now, once the police have sort of engaged in that, it can move further to a Terry pat-down, which is a reasonable belief by the police officer that the person might be armed or be holding something dangerous or potentially harmful to the police officer. So the police officer can pat down the outer clothing looking for weapons. All right. Now, if they're going to arrest somebody after this constitutional dance, they need probable cause to arrest. All right. And then, if they've got probable cause, you can do a full search of the person and the area within that person's immediate control. All right. So this is the stop and frisk scenario that the news has talked about so heavily. Our class, in looking at criminal law and criminal procedure, needs to understand the Terry stop scenario and how it advances. Right. So things that are triggered in this is how the police perceive a threat. Right. Now, when we're talking about implicit bias or we're talking about racial profiling, these play into the perception of danger or whether a suspect is a threat to a police officer. Right? The perception of unlawful activity is also informed by implicit bias and by racial profiling. All right? Thinking that somebody is engaged or engaging in unlawful behavior, when we're looking at whether that suspicion is reasonable, how somebody interprets facts to create reasonable suspicion may have a racial component to it. All right, and in the escalation pointed to by BLM, that perception of unlawful activity, right, is clearly, right, under the facts of the case, playing into race as a part and definitely a substantial informing element to that. Now, when we're looking at probable cause, what we assume to be probable cause can actually then deal with both threat and unlawful activity, right? And an interpretation of increasing numbers of facts. Just think about our conversation about being stopped on the way home from a birthday party. Right, the increasing number of facts led to probable cause, which then led to the arrest, right, of one of our classmates in that scenario. Now, something that can be at play here when we're thinking about reasonable suspicion is and the courts have looked at this, is time of day, location, body postures, things like this. So how you read somebody, another individual. So this is a police officer reading a potential suspect. Their reasonable suspicion, their interpretation of whether that person should be in this location at this time of day or night, right, plays into reasonable suspicion. It appears to be, right, an interpretive process that is very subjective on the part of the police officer, but points to various circumstantial facts, right, to bring it out of merely subjective and give it some amount of objectivity. That's what the reasonable suspicion standard in the law does, right? It moves it from subjective to some objective references. Right. Now, the use of justifiable force is also taken from the point of view of the police officer. Under the circumstances, whether the force that they're using is justified by the circumstances, which means we're also looking at the point of view from the police officer. And then the last piece of the puzzle here is officer safety. All right, so the pat-down, for instance, the warrantless search through the exterior of the clothing has to do with officer safety, but so does justifiable force. All right, so does justifiable force. And justifiable force and officer safety will depend on what our perception of a threat happens to be. And if our perception is racialized, then the force we used, right, can be escalated on the basis of race. What is viewed as a threat to officer safety can have a racial component that will help to exacerbate or escalate the situation. Right, so these are the things that are happening inside the law, right? The probable cause, reasonable suspicion, justifiable force, officer safety, based on perceptions of threat or perceptions of unlawful activity. And to the degree that race is playing into how a police officer is interpreting a suspect in a circumstance, we have an issue, and that is what legally is being triggered by BLM's critique. All right, now let's go to the next thing, which is the 1983 claim. All right, so statutory protections for victims of police violence. So I'm just tying this directly to BLM. There are ways of arguing 1983 for a variety of constitutional violations by the government or an agent acting on behalf of a government. But when we're talking about BLM, we're actually focused on police violence, right, against black people. And so one of the things we want to do then is say, all right, within Section 1983, what is the statute providing? What is the law providing here? And this is as a remedy of somebody who has been, whose rights have been violated by the police. So here's the language. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. All right, so let's translate this for a minute. Right, one of the first things that might be confusing to somebody without legal training is, what does under color of any statute, ordinance, regulation, custom, usage, or state or territory of the District of Columbia mean? All right, and the phrase here is color of law. All right, what does under color of law mean? It means that somebody is acting as part of, right, some sort of legal right or duty that they have, right? There's something that legally allows them to do what they're doing. So if they're acting under color of law, now keep in mind, they don't actually, the color of law doesn't necessarily mean that what they're doing is complying with the law. What it means is that that law is serving as the basis that's permitting their actions, okay? So if they're acting under color of law and they subject any citizen of the United States or other person in the jurisdiction, so you don't actually have to be a citizen, right, to deprivation of their rights under the Constitution, right, then the injured party can have an action at law. It means you can go to court and you can sue them. So that's the basic language of 1983. So how does this get used? Well, frequently it's used by people who've been injured when in police custody. It can be used by people who are injured during over-enforcement, right? In the Terry scenarios, it has been used in incarceration settings like prisons or jails for what's happening there. There are any number of circumstances sort of involving the police or the penal system and 1983 claims. Now, one of the things that will happen when somebody brings a 1983 claim, so let's go back to our sort of civil procedure class. 1983 is not a crime, right? It's not a criminal statute. 1983 is a civil statute, right? That means that a private person has a right to use the statute to enforce, right, and get a remedy for a violation of their rights. So within that construct of civil procedure, then somebody could file a lawsuit, right, against the police officer who injured them, the department, the people who supervise the police officer, the chief of police, the mayor of the city, right? They can, under a theory of employment superiority, right? This is which we've looked at, say, in our torts classes, right? So this is think of this as kind of a statutory version of a tort claim, all right? Now, when you bring that lawsuit, when you file that lawsuit, the defendants get to answer. So they get to deny your allegations. They could bring counterclaims if they wanted to, but they also get to assert their defenses. All right, which is to say, even if the facts occurred the way you stated them, these defenses will prevent liability, or which is legal responsibility, from attaching to the defendant. All right, so what are the defenses to Section 1983? And that answer is qualified immunity. All right, so let's take a look at this. So for the BLM movement, we are again focused on police violence, and the way that police violence can be remedied by a private person is through a 1983 claim. Once you've made the 1983 claim, the officer gets to defend themselves. One of their defenses is going to be qualified immunity, and this is what that defense says. All right, the legal test for qualified immunity by the court is this. First, a court must decide whether the facts that a plaintiff has alleged or shown, right, make out a violation of a constitutional right. Okay, so if we go back to the statutory language, we actually see that it's a deprivation of any rights, privileges, or immunities secured by the Constitution. Right? So that makes sense. The first step of the test is the plaintiff has to show, right, that there was a violation of their constitutional right. Second, the court must decide whether the right at issue was clearly established at the time of the defendant's alleged misconduct. All right, so this is very interesting, actually, because the second part is not contained in the statute. All right, the second part is not contained in the statute. It kind of means that when the court is interpreting this, what it's going to do in the second part of the test is restrict the application of 1983. All right, it won't be a broad application, which means it applies to many circumstances and people. It will be a restricted application, right? So it will apply to fewer circumstances and fewer people. Right, now, the historical development by the Supreme Court of the United States regarding qualified immunity is kind of threefold, right? Officers should be shielded from liability when acting in good faith. So that means that the officer has to have, under the first part of 1983, right, acting in good faith. What are they acting in good faith under? Under color of any statute, ordinance, regulation, custom, or usage, right, of any state or territory or the District of Columbia. All right, so under color of law. So they have to have a good faith, right, belief that they're acting lawfully when they engage in the behavior that they engage in, right? And then the Supreme Court developed that further, right? And the law that they broke, right, was not clearly established. All right, so if they have a good faith belief, even if they're mistaken, right, the court is then going to require that the color of law they're acting under, or what it is that they are breaking. All right, so pause for a second. Let me back up. Not the color of law that they're acting under, the law that they're being alleged to have broken, which is to say the violation of your constitutional right. It has to be clearly established. All right, what your right is has to be clearly established. And then the court further defines that, which means that for a law to be clearly established, it must have been beyond debate, right, that the officer broke the law, all right, beyond debate. So this almost looks like beyond a reasonable doubt, right? So it almost looks like it's with certainty of some kind attached to it. So beyond debate, there is not a cogent argument going in the other direction. So this is a very, very difficult standard for a plaintiff in a 1983 action to meet, all right? And the result of this is actually the case that I've assigned for the readings for this week. All right, so when you're looking at the Jameson case, What you're looking at is a federal district court judge. So he's a federal trial judge. He's in a district court in the state of Mississippi. And he's looking at a scenario where a black man is driving across the state of Arizona, and he's stopped by a police officer, all right, in a Terry stop kind of way. One of the reasons, right, that he's pulled over is that he's driving a Mercedes, and he is a black person driving a Mercedes, right? Now, the other indicia, right, of unlawful behavior is not apparent in the decision, right? But the officer nevertheless engages in a Terry stop, right, and begins to investigate. The officer put his arm into the car through the window. The officer had him step out of the car. The officer searched the car. The officer brought in drug sniffing dogs. The officer had the car torn apart looking for unlawful things or evidence of unlawful activity. None was found. The officer then leaves the man by the side of the road to reassemble his car. That man brings a lawsuit based on 1983. The officer defends himself with qualified immunity. Now, what the judge in that case does is rather extraordinary. The judge in that case walks through the history of 1983 claims and the origin of qualified immunity and how they work. The judge also walks through a whole number of cases that provide historical precedent, right, which control the outcome of our case, and the judge ultimately decides in favor of the police officer. Now, the procedural posture is very important here, and by procedural posture, what I mean as what stage are we in the legal proceeding. All right, so the plaintiff has filed a lawsuit, right? The defendant has answered the lawsuit and raised qualified immunity, and then the defendant has made a motion before the court to have the case dismissed based on qualified immunity. Right, and this motion to get a case dismissed asks the court basically to make a legal determination and to determine the outcome of the case, right? And if the judge agrees, the case would get dismissed. This is called a summary judgment motion. All right, it's a pre-trial motion. So all of this is occurring before a trial begins. All right, before the evidence has been heard by a jury or anything like that. So this is at an early stage in the litigation process. So qualified immunity is very powerful because it gets cases dismissed, all right, before they go to trial. And that's the decision that you're reading. That's the procedural posture of that case. The judge does not like dismissing the case, and the judge clearly disagrees that this is the appropriate thing to do, right? But the judge, being a federal judge, also has to apply the law, which he does, all right? And then he dismisses the case. But in his decision, right, he writes extensively about what the difficult dynamics are with this doctrine of qualified immunity and its application, right? And then he draws a parallel to another kind of statutory protection called a 1981 claim. You don't need to know about the 1981 claim, but I do want you to understand the 1983 claim dynamic and qualified immunity and how it works. All right, because for BLM, one of the things that happens, and happens very dramatically here, is that, pause for a second, there we are, is that even when somebody survives an escalation of police violence in, say, a Terry scenario or an over-enforcement scenario, and they bring a 1983 claim, frequently that 1983 claim will be thrown out of court, all right, on a summary judgment motion based on qualified immunity, Right. Now, all this does is deepen the legal precedent of how far a reach qualified immunity has as a defense, and the greater its reach, right, the smaller the ability that a Section 1983 claim has to help somebody get a remedy for a violation of their constitutional rights. Right. That's the dynamic involved in this case. Now, there are other sorts of dynamics that we're going to be looking at next week. All right, so I want to look at the Ferguson decision, and we'll be talking a little bit about the Wilson, who was the police officer in that case, and Brown, who was killed in that case, and how the grand jury operated in relation to that. All right, but for this week, I want you to focus on our last lecture on criminal procedure, right? And this on BLM and qualified immunity. So hopefully, when people are engaged in a debate with their family or friends, or you're watching a news story or something is happening, the legal understanding that you're going to bring to those conversations should focus on, right, over enforcement and racial profiling, right, moving into things like warrantless searches, probable cause, reasonable suspicion, right, officer safety, right, evaluations of threat, evaluations of unlawful activity, right, moving to grand juries and indictments and how probable cause works there, 1983 claims and how they operate, and qualified immunity as a defense and how it operates. All right, so those are the pieces of legal knowledge that we want to put into play for you here. All right, so again, please send me any questions that you have for Thursday's seminar discussion group, and we will tackle these topics and move through those questions with clarifications and answers, and then see if we can sort of come to a more comprehensive understanding for everyone participating. All right. Thank you very much. Take care. Good luck. Stay safe and stay healthy.